Hello everyone, welcome to Property Experts where we provide you information related to property in a sensible manner. Hence, before purchasing property worth lakhs and crores of rupees, please do watch our videos to never fall in any sort of a scam or a fraud. Well, today we are going to speak about how to transfer ownership of land in India. Once in a life, you have to transfer the ownership of land. In this, there are five types. Number one, sale deed. It is an agreement for transferring the property. All the conditions should be mentioned there. According to Transfer of Property Act 1882, in which definition of sale and purchase was written, in which there should be a contract made by both parties and the conditions should be applied. Things to remember for making sale deeds. Before buying the land, you need to fulfill many formalities, in which agreement is a very important aspect. It is a written consent, there should be a two parties and all conditions should be applied. The agreement should cover area of the land, location of the land, position of the land, part of land, mode of payment and negotiations. Amount of stamp duty should be charged as per the respective state. For example, in Delhi, women have to pay 4% of the total amount and 1% or 4%, whereas men have to pay 6% and the rest is the same. The biggest benefit is that you have to pay the transfer tax to the government and you can use it legally. The disadvantage is that you have to pay the fees for it. In Delhi, it is around 6%. Number two, gift deed. According to Indian Property Transfer Act 123, it is if someone gives the will of the house to someone from his own wish, so it's known as a gift deed. It can be offered as love or respect. The giver cannot ask anything in exchange. It is also a written agreement. The stamp duty is also the same. The biggest benefit is that you don't have to pay anything in exchange and you don't even have to answer to the income tax department. Number 3, release deed. When the owner willingly gives up on land and makes a will on the name of his closest friend, then it is known as a release deed. Things to keep remember in making release deed. This is also a written agreement. According to Hindu Property Act, the land can only be delivered to family or blood relatives. You have to pay a very low amount as a fee, and the lack of points is the one who gives up can cancel also. Number 4, partition deed. Partition is also one type of release deed. It's a family settlement deed, but in this property is transferred in small amounts, and the literal meaning is if you have taken a loan and are not being able to repay, then you can give a small part of your land for repaying. It is also a written agreement in which the date of loan given should be written. The benefit is that you don't have to pay a higher price. The loss in the wealthier one always puts the will of poor ones in his name by the given Tehsilda. It usually happens in previous years. Number 5, will deed. According to Indian Succession Act 1952, will is known as legally transferring the title of home to the one whose name is on the will after his death. One who makes will known as testator, whose name the will is known as beneficiary, and the one who takes care of the will is known as the executor. Wills are of two types. Number 1, privileged will. Number 2, unprivileged will. Conditions for writing wills: number 1 should be of 18 plus of age. Number 2 should be in written agreement. Number 3 should be two copies signed by both. Number 4, the property for which you write a will or the bill should be purchased by you. Fees are taken for the namesake only. Thank you so much for watching this video. I hope you have learned a lot through this video. Do watch all our stuff so that you have no doubts regarding property. Thank you.
Related help, please contact us. Thank you.